Dear participants, dear friend, this is our last Global Digital Encounter of the year 2024. So it had to be, and it shall be, one of the most beautiful ones of the year and of all Global Digital Encounters. We shall talk in academic capacity on an issue that is central to business and to society, protecting and enforcing digital marks and designs. Why is it so important for society and for businesses? Because since the advent of the internet, progressively, business moves very much to the digital world. The world of designs also moved to digital, to activities on digital support, to the use of digital networks. And clearly enough, there is a transformation of the contents and of the methods for designs and for trademarks. This is why in this year 2024, where we spoke a lot about artificial intelligence, about blockchain, about 3D printing, and about all other questions related to the evolution of the IP system. This is why we want to dedicate this last digital encounter of the year to the evolution of the protection of industrial designs and of trademarks, and the evolution of enforcement of industrial designs and trademarks in their digital format in the digital world. So our purpose goes in many directions, and this is why for this very global digital encounter, we have chosen exceptional speakers, exceptional panelists, and an exceptional moderator. We've got with us, of course, Judge Virginia Melgar, who is chairing one of the appeals board of EU IPO and has a long and worldwide experience of intellectual property in all its formats and in all types of rights, and not only trademarks and industrial designs. And we have with us Dr. Yuna Sheu, who is the Director General of the INDICAM, the organization that supports, protects, and defends the right holders, among the most prestigious right holders of Italy and Europe. She's got an immense experience, a wealth of experience in this activity that she has performed in many capacities for many, many years, and that makes INDICAM shining as one of the most dynamic organizations in Europe and in the world in this respect. The debate will be moderated by Dr. Ruben Cano Perez, who is at Baker McKenzie in Madrid, but also an academic fellow at Bocconi University. We are very proud of this. And as such, we would like to discuss in academic freedom of a topic that is a reality in our present, but also a challenge for tomorrow, a challenge clearly for IP officers, a challenge for the courts and the Court of Justice, and a challenge for potential and actual right holders. Well, with these words, I would wish to wish all of you a splendid global digital encounter. I would wish to thank all our partners from all over the world that support this pro bono voluntary activity made by all of us. And since I only make the opening of this global digital encounter, that will then be closed by my colleague Manuel de Santos, I would wish to present my season's greetings to all of you for an excellent year 2025, full of beautiful global digital encounters, covering many, many topics of intellectual property that we want to introduce together. Well, Javier is our coordinator. Professor Javier Fernandez-Asqueti is our coordinator of the Global Digital Encounter teams, and wants also to welcome you to our 37th session. Javier, the floor is yours.
Thank you. Thank you, Laurent. And very briefly, as usual, I remember some years ago I heard the CEO from Telefonica telling that there is not a digital world and a real world. There's only the digital life and a real life. There's only one life. And this is a situation we're facing now. I mean, we're living in a real and digital life, and it's the same life. So that's why the trademarks are affected by this new situation we are facing. Trademarks and designs are facing this new situation. That's why this session today will be very important to know which will be the evolution of trademarks in the future because of this new situation we are facing. So thank you very much for organizing this event, and I'm sure that this will be a success. Let me wish all of you the best in these seasons, and the best for 2025 when we will continue with the digital encounters. And thank you very much. The floor is yours, Ruben.
Thank you very much, Javier. Thank you very much, Andrea. I'm honored being here today. I also extend my gratitude to Fide, the Global Digital Encounters family, which I'm part of proudly. And thank you also to Virginia and Juna, who will actually today give us explaining it very useful input on the topic. I wonder to kick off. I want prevent the speakers to give their insight from for a long time, but I wonder whether we are facing a new phenomenon, a new context. I in my personal opinion, I doubt it. I don't think that it's a new phenomenon. I think that we are facing a challenge that comes from 10, 15, 20 years ago that is being, let's say, is changing, is evolving, and that in those changes of the same phenomenon, of the same digital context that we had since the advent of the internet, are kind of prompting us or urging us to adapt or to accommodate to these new challenges. So some argue that in the recent 5 to 10 years there have been more applications connected to shape trademarks or multimedia trademarks due to this new accommodation to the reality, maybe because for some reason right holders weren't attracted to apply or didn't have enough knowledge to apply for this type of protection, and also some others outline that even if there is some IP registered, there is little to no enforcement of those IP that are kind of registered for the digital environment. So I think in that intersection, in that kind of space, our conversation is so useful, and your insight, Virginia and Yuna, is so useful. So as I was mentioning before, in the context of new business, new ways of communication, new ways of creation, of presenting products and services, I wanted to start with Virginia, if you agree, on the question of what are digital assets. I mean, for instance, starting by trademarks, what are digital distinctive signs, if there is a definition of those?
Thank you, Ruben. Hello, everybody. Well, there's no such a concept of digital mark. What we find is the concept of digital marketing. So the way the companies are promoting their goods and services. And that means an environment or a support, which is not the traditional one, catalogs and the advertising in TV, but more social media, websites, Instagram, TikTok, and of course, online platforms. So we don't have in the list of possible type of trademarks in our regulation Article 4, we don't have something like called digital mark. But of course, the last reform in 2016 opened the door to all these companies to register, because we deleted the condition of physical graphic representation. And of course, you can file an MP3, a little video, and therefore opening the possibility for covering all these digital marks using the digital world, I would say.
Yeah,
Thank you,
indeed.
Virginia. Yuna, please.
Yeah, hello everybody. It's a pleasure to be here with you today. Thank you, Ruben. I totally agree with Virginia. There is no definition yet about digital marks or digital signs, but it is challenging because the application of and the evolution of today's world makes challenging the application of these IP assets in the digital environment. So I would say that digital marks, so-called digital marks, are used is the use of the trademarks in the digital marketing, in the digital world. So we see from our day job that right holders, brands are trying to adapt their strategies, their brand protection strategies as well to the digital environment. What we have seen recently is that a lot of right holders are starting to register the trademarks as well in the commodity in the class 9 of the classification of NIS that it is that has entered into force starting from January 2023, which permits to the how I can say, to the traditional trademarks to be applied, to be registered as well in the as for commodity use in the digital world. So the download of digital files authenticated by non-fungible tokens. So in the class 9. So this is what we see today happening.
That's really enlightening. I mean, how we moved from one conception of products and services, and in my experience also some bad use of NIS classification in some cases, pretending that everything is digital, even if you're not providing a digital related product or service. And from that, maybe Yuna, you can also provide some insight on also on the other side of the coin, given that we are speaking about trademarks and about designs, whether you see any digital design definition in the current ecosystem.
Yeah, in the current ecosystem, I can absolutely mention the design package. I mean, we have been recently been granted with this piece of legislation, which was a lot awaited from brands, from entrepreneurs, because it has updated the definition of design to encompass as well animation, which so animation is a broad term which includes both movement and transition when we are talking nowadays about design. So this was absolutely way long awaited reform and very welcomed from brand owners, right holders. So absolutely the new definition of Article 3 has been granted new or fresh air to the needs of the right holders. And another novelty way long awaited is as well the product definition, which now a product has been revised to explicitly include as well non-physical items. So this is another novelty that our legislator, the EU legislator, had thought was the right time to introduce for adapting to the times we are living. And other things that I can say that of course As I said, the product can be as well any industrial or handcrafted item other than the computer programs, regardless of whether it is embodied in a physical object or materialized in a non-physical form. So this is absolutely something that represents the times that we are living. Yeah.
Thank you, Yuna. Maybe Virginia, you can complement, provide
Yes.
some additional comments on that note.
Yes, what I see is that for trademarks that wanted to be registered to be used in the digital or as digital marks, let's say in a digital environment, it has been much harder. The registrability has been much more difficult than for designs. For designs, we have hundreds of design registrations for graphic interfaces, for icons, without any issue. While for trademarks, there's a consistent trend, not only from the boards of appeal, but also from the court. I mean, the times the cases were challenged before the court confirmed that these sort of, these icons that we have in a smartphone, in the apps, were not particularly distinctive. And that, the level of distinctiveness was very demanding for this sort of signs, the signs we have in our iPads, in our smartphones, because there's this idea either that they don't function as a badge of origin, or that you need to keep free a certain number of representations that are used for everybody. So in this regard, we can quote all the examples from, for example, from Apple for icons that are in the smartphones, the agenda icon, the different icons that, for example, you have a wrong password, etc. They were filed and almost systematically refused on the lack of distinctive character. While at the same time, although, as Yuna said, we have a very traditional design definition of the appearance of a product, and you needed to file all these images, the registrability was much easier. So now you may say, well, we have a wonderful legislation for designs that will enter soon, the first phase into started to be applied. And the trademark legislation reform of 2016, in fact, we have a different, not a real parallel evolution. I think it has been much more difficult for right holders to get through a trademark, which is, as almost always, a figurative sign or a 3D mark without verbal elements, much more difficult than for designs. I see a difference there.
Yeah, if I can jump in, Ruben, I think that regarding trademark, another challenge is in terms of enforcement nowadays, according to this not balanced legislation that is now going on compared to trademarks and design, is as well the difficulty to enforce and to prove that the trademarks are used in the proof of use that the trademarks are used in the digital environment. So this is another challenging proof that the right holders have to demonstrate nowadays in order to have their rights, to see their rights enforced. Do you agree, Virginia?
Yes, I think that there we might say, for example, for proof of use of trademarks, which is the most challenging difficulty for enforcing them when they are digital, is we have some sort of, I mean, perhaps not enough case law yet, and sort of different angles. So you cannot really say, of course, there's no problem with social media and websites, and there are problems linked to the support, this digital support, the link with a territory, and the proof of a date and a certitude about a date and a territory. I see here, I draw the attention on two important convergence practice that the office has reached with national office. One is the CP10, which is about the designs disclosure issues, and CP12, which is about the evidence. And it's a very good summary of what the case law is so far for evidence. And we have very good signs. For example, in the Mood Media recent case, to March 2022, the court says that, of course, the use of a mark may be done through social media, websites, domain names, etc. So a very positive approach. But then, of course, when you enter the detail of, territorial, nature, extent, which are the classic different aspects of use, you enter in the difficulty. How you measure is not the number of users or followers, is how you prove that they identify or they can see that as a badge of origin, use as a mark. So I see different signs. For example, another recent case where the court said that these APIs, these application programming interfaces, were a good way of proving use. A very recent decision of May this year in a case called VAPIX. In another case, this device of an O, a case of February this year, the court established that, of course, using the social media for cosmetics is absolutely okay, provided you bring the evidence that in spite of this digital environment in which the mark is used, the mark is used as a trademark enough and sufficiently to prove the extent of use. So we have very positive signs for these new technological challenges, but at the same time, we have the classic test. So companies should look carefully at these two conversions practice I mentioned, because there are some recommendations how to avoid a problem with the office.
I think that's quite insightful. That reminds me of a very old problematic that also Professor De Santi that may be around of private international law, which refers to the mere accessibility or the targeted activities, so whether it is enough to access the content or the use has to be in that particular jurisdiction. So on that note, and given that you mentioned the some very interesting case law, and is there some criteria that any of you now, Virginia, can provide in that context in order to prove use when we are facing digital goods or goods that are or services that are being provided in the digital context?
Yeah, Ruben, right holders and their legal advisors are trying to adapt the proof of use, the traditional proof of use that it could consist in mere price lists, showing price lists or catalogs that agents or DOS or retail shops were providing to the people in the territory. Pardon. Now they are adapting the concept of the proof of use to the digital environment. So now it can be used as a proof of use of a trademark. The interaction between the website of the right holder, where the trademark is shown, with its customers, or any investment in a digital marketing strategy that is being shared in the website, and that he has proven to has had interaction between customers who perhaps put a like or comment the advertising, the digital advertising campaign. So these are proven to be in terms of going beyond the traditional proof of use, are being proofs, digital proofs accepted by the national court, by the Italian courts. So the right holders are updating their onore della prova and the right of proof to the digital environment. It's not easy at all. Sometimes we provide screenshots of the website, of the interaction of the chat box where the IP digital manager is interacting with the customer. So these are proven to be nowadays some useful proofs for right holders.
Ruben, what you may think it's a traditional product or service that implies a sort of tangible premise and tangible things, like, for example, hotel accommodation. Well, in fact, because what surrounds this tangible activity or service is done a lot through a digital support. For example, advertising, the clients that come from outside that place because you have advertised, because you can pay a service from anywhere around the world. Well, the General Court has done an interesting move in that direction in the case of the standard, a judgment from 2022, where the challenge for the applicant was to prove for the opponent was to prove that although the hotels were physically in the United States, the use of the mark for hotel services was taking place in the EU. So you had a sort of two different issues: premises, physical buildings outside the European Union, in the United States, and then, of course, all the digital activities surrounded by these offers from the hotel chain were taking place, of course, among other territories in the EU. And although the board said that, in their opinion, there was no proof of use in the EU, the court said no. And may I read a very interesting sentence saying, a distinction shall be made between the place of those provisions of services and the place of use of the mark. Only the latter is relevant to examination of the genuine use of a European Union trademark. Even if the applicant were to supply goods or services outside the European Union, it is conceivable that the applicant would make use of that mark in order to create or preserve an outlet for those goods in the EU. So all the digital activities that were done by the hotel chain to promote the hotel, to attract clients, was use of the mark, while the place of the services was outside the EU. I think that case, of course, obliges us to rethink, even for services which you think are physical, to rethink, of course, this sort of dissociation between something that is physical and the use of the mark, which, of course, takes place in a digital environment. So I think that judgment is very promising for right holders, even for what you suspect is a physical building with some sort of services for clients.
Mm-hmm.
In that context, what you say is tremendously enlightening, because we have services that may be provided by
online.
Online. I don't know, maybe from India or from in South Africa or wherever you want. And there's some type of services and products that have to be actually provided within the location or within the country that you're aiming at so to speak, targeting, no, or that you want to provide proof of use. And in that context, I mean, should we make a distinction depending on the nature of the product or service, or on the other hand, proof of use and use in a particular territory is the same, regardless of the nature of the product?
$1 million question.
If I can jump in, Ruben, I think that now entrepreneurs, right holders are very much preoccupied in entering the market with their product, the different markets with geographical markets with different strategies. So I don't think anymore, and our members do not do the traditional way of entering a market. Now there is assessment of the geography where you want to present your product, and so in case it is a non-EU territory, then prior entering a product or a trademark, it is absolutely a useful due diligence if they're in the territory, the trademarks already exist or the design already exists. If not, it doesn't exist. Absolutely, it is a good brand protection strategy to absolutely register your trademarks, your distinctive signs, whether they encompass all the characteristic and the requisite that they should have in order to be registered. And then, so absolutely, right holders nowadays, they invest a lot of money prior in their products, in their trademarks, prior entering a different geography. So absolutely, it has to be a tailor-made strategy, and absolutely entrepreneurs should be very attentive whether they are entering an Asiatic market, either a European market, either a US market, because there are enormous differences and protection and application of enforcement and protection to their distinctive sign in different parts of the world. So absolutely, I do not recommend a uniform strategy as it could be in the 50s or in the 60s for entering a market. And no.
Ruben, no, seriously, I agree with Juna, and I will say that the territorial condition is more and more blurred because of the digital economy. And of course, you get aware of brands and you recognize this as badge of origin, even if they are not physically beside you. And this is in the judgment, the court talk about globalization in a digital environment, and that's exactly the point. Of course, we have the other conditions still to be proven, but this old territorial requirement, which does not fit with the current economy we have, is, of course, I think after that judgment, really blurring into much more market reality. You are using the mark, although your hotel is in New York or Los Angeles, of course, the services are there. So I think the question is, yeah, I think we are going into a new approach of territory.
And that's quite a that's quite a new. So I think that's quite a highlight of at least of the session. And in this case, you were also mentioning before, I mean, some tips for preparing evidence and how you can prove evidence. And God knows that whenever we receive the evidence, we find whatever things, and sometimes it's difficult also for companies to retrieve evidence, or for in-house lawyers to gather all that evidence and to kind of, how can I say that, to persuade or to set that culture of evidence generation within the respective companies, right? And maybe there is a difference between EU right holders and non-EU right holders when they approach this type of task, like let's call it evidence generation task, right? So have you perceived in your experience a different approach between EU right holders and non-EU right holders?
Well, I think I would say that whatever their origin, I think many companies, as Juna said earlier, struggle with the new tools used for the marks and the designs. And we see cases in which, for example, if you are going to prove reputation, is extremely difficult to show only with the digital marketing strategy, where is the recognition as a reputed sign, and how do you prove reputation only with that? So I don't see any difference between Americans. I think Americans, because of their legislation, are more prepared and are more trained in proving use, probably because this is something that they do much more on normal basis than our EU right holders. But I think in general, everybody struggles with the new tools that we have. And probably, yes, Americans less because of their usual system protection through use. So they are more used to collect use. I see difficulties, for example, in the use of Wayback Machine, in measuring the impact in terms of numbers of followers, or as Juna said, the interaction, very difficult to measure the interaction. You have very sophisticated tools nowadays. And of course, if you are a small, medium-sized company in Europe, maybe you don't have the means to gather all these from the beginning in order to be able to face a challenge on the proof of use. So I would say, yeah, because of the national legislation differences, probably the Americans are more prepared or used to file and gather this type of evidence.
Yeah, Ruben, I share the same opinion. I mean, from our experience and from the experience of our members, we see that it is much more easier to enforce digital rights in the U.S. courts, but it's not that easy, though it is expensive, but it's not that easy in the Asiatic courts, because this is a very challenging language barrier. It is a very costing investment for right holders to prove, because all documentation proved, though digital documentation, how I can say digital proof, it has to be reported in a hard copy, in letter, in paper, and you have to authenticare, so you have to notarize it. So there are additional documentation that you have to prove, and the financial burden, it's a lot over the European right holders. And yeah. I mean, it's challenging to apply for enforcement in non-EU or US courts. This is our experience. Perhaps it's better with Indian courts, but some Chinese less main cities courts, it's not that easy. So it depends a lot whether we are enforcing these rights in common law jurisdiction or other jurisdiction.
And that's definitely makes sense, and it kind of show us how difficult it is to manage your global portfolio, right? Even, I mean, designs or trademarks, every jurisdiction which with different standards, and how, I mean, luckily enough, we managed to have a regional approach on the matter, and we kind of help right holders as well from the EU and from Virginia from the EU IPO to have kind of a common approach, a 27 countries common approach to handle these type of issues, also with the with the convergency practices guidelines and the guidelines from the office. I think that's quite a difference. And for those as you and Virginia and that actually are familiar with different ecosystems, gives us the perception and some, let's say, thoughts about how difficult it is to, as I was saying, to manage a global portfolio of marks or designs. And beyond this proof of use issue, on the enforcement front, could you maybe, Yuna, outline a case familiar to you of existing design or trademarks that was applied to the digital environment to outline which was the problematic and how you see that evolving?
Oh yeah, Ruben. I will share with the audience I think one of the most famous, well-known case laws in Italy regarding it was a decision from the Court of Rome issued in 2022, which the particularity was because it was our first order concerning non-fungible tokens ever published by Italian courts, and it regards the case law that involved the Juventus Football Club, which has been which brought to the court a European crypto company who has launched in the early 2021 an online fantasy football game based on NFT cards, and which embedded players, football players who have the different shirts in jersey representing the football club, and in this case they were representing the Juventus jersey shirt, so with the Juventus trademark applied on. So and of course it was as well portrayed in this case a famous former Juventus player. So the Juventus football club has, in the meantime, has entered as well the NFT industry, operating in a license agreement with another Italian company for launching its own NFTs cards. So when they saw that this crypto company was already entering the digital market with this football game, they immediately filed a petition and a statement of defense for blocking this activity, and they requested to the Court of Rome to prohibit the respondent from further minting and marketing the cards portraying the player wearing the Juventus jersey, and as well any other NFT displaying its trademarks. And the respondent back then instead submitted that Juventus could not enforce the issue trademarks because they were not registered for the commodity classes that included the downloaded virtual products such as NFTs. What I said back. So and the importance of the decision regarding the Italian the Court of Rome, and so the Italian case law was that though the NFTs were not, though Juventus has not registered those trademark in the commodity classes, they had such a reputation, as Virginia was saying, they had such a reputation for the Italian law that the trademark had the existence of a widespread merchandising activity in various sectors, and it was documented. So the NFTs were indeed leading, were indeed were indeed interfering with the IP rights of the Juventus Football Club. So this was the importance of this decision, because it was confirmed under Italian law that NFTs do not grant ownership over the underlying intellectual property rights unless the parties agree otherwise. So this was a first case decided by the Court of Rome that opened the way to the legitimate right holders to enforce this their IP rights, even in the digital environment when it concerns to non-fungible tokens.
Ruben, tomorrow we have the first judgment from the court, where the question is whether we should reason and assess a trademark for virtual goods to be used in a virtual environment the same way we assess the same mark for a physical environment. And the response the board gave was yes, should be the same way. So we shouldn't accept a mark that is somehow descriptive anyway, because it is for virtual goods. And let's see what the court answers tomorrow morning, if this is the approach. Juna said, yes, we have a lot of applications now in class 9 because of the use in a virtual digital environment. Let's see if the court agrees that the way we look at designs should be the same, where we are talking about to be goods that are going to be virtual, or the same traditional approach for physical goods. The case is called Glashütte, a well-known place in Germany for watch manufacturing. And let's see tomorrow morning if the assessment was correct or not. I wanted to say something, maybe we are too positive on the possibilities of proving and enforcing a mark on the digital environment and the positive approach of the courts. In designs, that may be an issue. If you have, for example, posted a photograph in Instagram of the new fantastic shoes, or you are reproducing the design very clearly in a social media account or in a website, that may be considered disclosure in the sense of the European Union design regulation. So if you want to avoid the disclosure of something that you're going to pretend or protect as a design, then you have to be careful with the use of digital tools, because we have a very consistent case law, and surprisingly, even a picture posted on Instagram of a pair of shoes, the court accepted that was a disclosure, because the court said you can zoom in, and so you can see all the details. You know, the appearance of a product is clearly available through the technological means we have. So you can zoom on the shoe, and of course you see all the features. That's a recent decision of March 2024 in a shoes case. So the use of a design in social media, in website, in Instagram, in TikTok accounts may be a disclosure. There's now a very consistent case law. So there has to be, if you don't want to disclose, you have to be careful of not putting anything in your LinkedIn account or TikTok, or making, you know, a very nice transmission saying, "Oh, look at the new shoes with new features." So there it may be counterproductive, a massive use, while in trademarks it is of course encouraged, as Yuna said, in order to, you know, give evidence of the use, give evidence of the reputation, prove that you have acquired distinctiveness. It may be done, through the social media accounts, through the Facebook, through the website of the company, etc. So in designs, you need to think about, the next strategic moves, because this is really clearly considered disclosure.
And Virginia, what you have already said about design is very true. Sometimes we see that different departments of a company do not talk to each other, and perhaps the marketing department goes for a launch of a product or for a advertising strategy without consulting the brand protection team or the IP legal director, and there are this kind of problematics for brands. So a good strategy, a good brand protection strategy as well for a design company is to set the strategy all together by involving all the department, the development and research department, the art director, the marketing department, the legal director. Is not to call the legal director or the brand protection team when the problem has happened. So to prevent, this is a good assessment brand protection strategy to customize the strategies according to the IP rights you want to enforce or to disclose or to launch in a territory, whether being it offline, and moreover now that we are talking to a digital environment.
Yeah, but it's the personality of creators that want to show immediately the art. It's very inherent to the creativity of the design world. Look at the new pair, and look at the new collection for collections of big fashion firms, and then you have an issue, and then it was disclosed in that TikTok connection or that Instagram post. So yes, I think your advices are really, really I fully support them. Don't talk to the lawyer at the last moment. Yes.
Otherwise, Chinese will have copied everything and launched it.
I think that what you said is again, I mean, I'm learning a lot and I'm enjoying a lot your interaction. I think there is a huge difference when we're talking about like digital means and the use of digital channels to promote or to advertise or to disclose, let's say, physical products, as you were mentioning, shoes, or or in the case of Juventus, furniture, you name it. Then on the other hand, there are other like digital native services or products or designs or trademarks. On that note, maybe I was thinking that to some extent designs are not in the enforcement front, are not that much used by right holders as compared to, for instance, trademarks, which maybe because we have a different, let's say, standards, because we are dealing with different rights when it comes to protection and registration. We have, I mean, the Virginia was outlining that we have more registered designs that could be applied to the digital sector. And in that note, why, in my experience, I didn't have that, I mean, a lot of cases, or I didn't see and could review a lot of cases of digital designs being enforced. Do you have any thoughts on that, on why that could be the case, that we don't have that much designs on digital, maybe emojis or graphic interfaces being enforced in practice?
Well, I think it's difficult for me to say now. European Union design, so used to community registered design. First of all, I think it's not used at its full potential. It's a very fast and very quick. You get a right that you can enforce very easily. For example, if you are preparing the launch of a product, or you're going to an exhibition, or for the first time you are in a fair in an international context, is not used as much as it should, because it provides a very strong, very fast and easy protection. And of course, it can only be, let's say, challenged through an invalidity action. And you see the statistics, there are very few invalidity actions. And when you get an invalidity action, it doesn't mean automatically that the design registration will be canceled. So I think it's a fantastic tool, and with the new legislation we are so happy to have now, it's really a very good answer from the legislator to the digital economy, and it's, well, registered in a few days without an exhaustive prior art, novelty, an individual characteristic check. So you get your right immediately, and you can go out and compete and use all the tools you need. So I think we have seen an increase in these last 3 years of design applications. And we don't see any major issue of enforcement. Of course, as Juno said, there are territories where it's difficult to enforce any IP right. But I mean, in Europe, it goes and it works very well. And in particular, I think in certain sectors, it answers a very good demand. You know, when you have a lot of products which are in a short cycle, you can really go for the new collection for every single type of model, something that is not easy with other type of IP rights. So I think it hasn't been used up to the potential, and I'm sure with the new legislation, we are going to receive much more, and for sectors perhaps that are new to designs. So Ruben and June are going to be very busy in the next month, advising the companies about the new possibilities given for. Imagine, for example, an architect firm, you know, doing with AutoCAD and all these fantastic tools, showing how the building will look like. You can protect that, something that was not so straightforward before. So there are really, I think there are a lot of potentials in design which have not been used, and we don't see any major enforcement issue, like you may see with, for example, multimedia marks, which have other challenges.
Yeah. I am absolutely just a minute of the thing to share with the audience. Yeah, I think that there are no major problematics regarding design. As Virginia said, the piece of legislation, the design package, offers great opportunities for right holders. I think that we have seen less use of designs because we are still a little bit rooted to our past, to our traditional way of thinking. When we think about trademark is the first presentation of an entrepreneur, of a company, because it is the first mean that you have for your reputation. So that is why we have seen in the past a lot of enforcement or a lot of decision concerning to trademarks, because the entrepreneur sees the trademark as its first business card or reputation of the first impact, of the immediate impact. But now I see as well that things are changing in the last 2-3 years, and absolutely we will see increasing numbers in the following months, weeks, or years regarding design. It comes from the traditional past approach that investments of the portfolio were done more over the trademark, but now things are changing. Absolutely.
Yes, I agree.
That's really useful. Maybe I will, for the interest of time, also open the floor for questions briefly. And we have one of our very dear Philip von Kaff that Virginia may know very well, as I do, with a very vivid and fantastic experience at the UIPO. And he's asking that it seems to be a misunderstanding on the digital service under the NIS classification. And the specific question is the protection of a trademark for virtual perfumery in the metaverse in class 9 appropriate? I mean, can the perfumery be downloaded if it is the metaverse? Isn't rather an entertainment service as part of the game, or a software as a service instead of a, let's say, a perfumery related product?
Well, you know, we took after a long thought and coordination with our member states, we took the approach that this should be classified in class 9 and in the corresponding services, so 38, 35, and 42. Now, we don't have yet a feedback from courts whether that was the absolutely correct approach in terms of classification. You know, in WIPO, in Geneva, there are continuous, in the technical committee, there are continuous discussions, because we all face the same question, whether that was the appropriate. There are people taking the view that if you're applying for a virtual perfumes, it could be a subcategory of the perfumes classic class 3 category. This is a valid point of view. Is not the approach we have taken. Let's see, maybe tomorrow we have the beginning of an answer where that classification strategy was the correct one. But we had to take into consideration all these new digital tools that allow the business to, I mean, think about the Birkin Hermes case in the United States. Of course, Hermes is producing real bags, but of course, there's also a full world of virtual bags in the metaverse. And are they bags in class 25, or are they software that allow you to see a bag in class 9? That's a question that is very soon to say that it's the correct classification strategy approach. As I said, we went through a process of cooperation and talks with our member states in order to have a clear approach. But the court will tell us in the next month whether that was correct or not. And let's see what the developments in WIPO, in the NIS classification committee are. Maybe we have a different view in 3-4 years. If we are all trading in the metaverse, maybe we have a different approach. But in the Glashütte case that is mentioned, thank you, Philip, in the chat, this is a place very well known in Germany for watches, and the application was for virtual watches, class 9, not class 14. And of course, the argument of the applicant is, we are not talking about watches. Why you challenge me on the fact that this is descriptive of a place related to watches? Because we are talking about software, basically. Now, let's see what the court answer to that is. We should have the encounter on Thursday, so we could have profit of the judgment released tomorrow morning. But it's an open question, Ruben, so far.
And that's I think that's really enlightening. And if we had digital encounter on Thursday, there was so much insight and that we couldn't have provided. So I think that's just quite timely to have it today. And maybe I will give you the floor, both of you, Una and yourself, for 1 minute, for 30 seconds. If you want to make any closing remarks on your intervention, on the future you see of digital trademarks and designs to close the sessions. And thank you very much. Let me say to both of you, because it was actually great sharing the flow with you today. Una.
Thank you.
Please.
Yeah, thank
You want to
you.
start?
Thank you, Ruben. Yeah, indeed, it was a pleasure for me. I learned a lot from Virginia. Thank you for sharing all this case law. No, I mean, I feel pretty positive for the future. I mean, I see brands that are adapting, evolving to the times we're living. So I think that the design package will help a lot. Perhaps we need to have some refresh or update regarding trademarks. So I would think that would be the next step that we would like to see in the next 2-3 years, but even earlier if it's possible. But I think that the beauty is yet to come, and we'll meet in another encounter online meeting to talk about it. Yeah.
Yeah, thank you, Juna. I also learn a lot about the strategies and how to debate with the marketing departments. I want to mention. Do you read?
No.
Yeah, no,
No.
you have the background. You have the virtual background.
Yes.
And now
Now,
we
yes. Just
we
freeze
publish a report which is a compendium of all the enforcement of all IP rights. So that includes copyright and patent. The last report, it is available in our website. The last report is October of this year. And there you have the enforcement and infringement cases that we have gathered from all the different courts in the European Union. So I agree with Juna. You have to design your strategy very carefully, and that means involving the legal department and the IP colleagues as early as possible. And as you said, Ruben, customize the strategy. You may be a global player, but you need to know locally what's going on. And I am also very positive for the future. I think, of course, the legislator cannot anticipate what the market reality is, but I think we are really catching up quite in a good pace.
Fantastic. Thank you very much.
Thank you.
I give the floor to Professor De Santis. We cannot hear you. You have to unmute yourself.
Now, it's fine. So thanks there, Ruben. Thank you, my academic son. Yeah. Having had you as a moderator of this 37th encounter already has been a great pleasure and a great honor, especially for me, Ruben. So there, Juna, there, Virginia, we are also very, very grateful to you. Be welcome to the family of our encounters. It's a family already composed by more than 100 of remarkable scholars and professionals. That's quite a team. Yeah. Indeed, I have the feeling after having listened to you that protecting and enforcing digital marks and designs is indeed a great challenge for companies, a great challenge for right holders, for users, also a great challenge for our society. And I have also the feeling that we could have spent many hours reflecting on many other issues related to the future of this challenge. Yeah. But believe me, you will be surprised when reading and recognizing in the report how many issues have you brought in just 1 hour. Let me highlight just some of them that come to my mind on the spot. You know, for instance, the fact that there is no definition of neither marks, neither digital marks, no digital designs. But the fact that the deletion of the requirement of physical representation requirement, I think you mentioned in 2016, yeah, opened a new avenue for this protection. Of course, you have also mentioned questions like the design disclosure issues, the evidence, if I recall well, how APIs, Virginia, can prove the use, or how, thanks Ruben for that, how private international law techniques, let's say, your methods as access, yeah, can be used for this purpose. The difference between the US and the European approaches, or even the iconic Juventus case brought by Juna, or the first words provided by Virginia about tomorrow's morning judgment of the court on the Glashütte case, yeah, where the issue at stake, if I recall well, was what time means in the digital environment and digital watches, yeah, in the metaverse, yeah. By the way, class 9, as Virginia highlighted very well, yeah. So, but what I have personally very much appreciated today from you three is your disruptive attitude towards the future of digital marks and designs, and the need of abandon what I would call the more classic and conservative views that were designed for the purely physical world. Yeah. For instance, it comes to my mind now the reference to the fact that the territorial requirement that has been for many years the pillar of our legislation is today more and more irrelevant in the digital environment. Certainly, someone talking, but anyway, I will go over this. Yeah, this new era must be addressed with new strategies and new tools. No doubt. Yeah, and the question of Philippe von Kapp's shows this. Yeah. So thanks again, Juna, Virginia, and Ruben for enlightening us with your thoughts, and many thanks also to those who have attended the encounter today. Also thanks to all those hundreds and hundreds who will listen to the recorded copy of the encounter in the following weeks and months. They will discuss it privately later on in conference, in social networks. We are happy to realize that the encounters are consolidated, Laurent, after 37 editions, and that the encounters provide a formidable tool to professionals, to academics, and to students. So take care. And join us for the next encounter. The next encounter will be the 38 already. It will take place in January 2025. And there we will discuss, as usually, new avenues for the IP in the 21st century. We will disclose the day, the topic, and the speakers in the very, very following days, certainly before the end of the year. As always, we will prepare materials for you, like in this case, references for you, and we will provide splendid speakers. Yeah. So thanks for being with us today. Enjoy the rest of the day. Greetings to all of you and to your families, and we wish you a wonderful Christmas days and a new year full of promises, but overall a new year, I should say, much more peaceful than the year that we are at the verge of living. Bye-bye. Thank you.
Thank you.
Grazie.
Thank you.
Thank you.
Thanks to all.
Thank you. Bye-bye.